Thank you very much, Professor Strauss. And let us now turn to a member of the working judiciary to see if he's a broom sweeper or not. And I want to call upon Michigan Supreme Court Justice Stephen Markman. And I must tell you that one of my colleagues, Judge Bailson on the Eastern District, who was at the same time as Justice Markman, a U.S. attorney in a different district, of course. Judge Bailson tells me that any panel with Justice Markman is destined to be a successful panel. And I can see why, seeing Justice Markman's CV here. He's a graduate of Duke University and the University of Cincinnati Law School. He went into Washington to begin a distinguished career in federal government, having, as I said, he was the U.S. Attorney in Michigan, but before that, he was an Assistant Attorney General during the Reagan administration. He was, and there he headed the Justice Department's OLP, the Office of Legal Policy. And he has worked with the folks in Congress as well, being Chief Counsel to the Senate Subcommittee on the Constitution, as well as working for the Judiciary Committee. He's obviously authored many, many articles and has served on the Michigan Court of Appeals and now on the Michigan Supreme Court. So I welcome Justice Markman and again invite you to either speak there or up here, either way.
Well, I appreciate that introduction much more than one I received not too long ago when I was introduced as one of the finest judges that money could buy in Michigan. I think they were trying to say something nice. I'm just not sure it came across the right way. I know my wife felt the same thing. She was sitting with me on the dais when she was introduced by the same master of ceremonies as being one of the finest ladies to walk the streets. And, She was similarly perplexed. But I thank the Federalist Society for the opportunity to participate in this panel. It speaks to an issue that's concerned me for some time as a justice of the Michigan Supreme Court, and I'd like to briefly share my observations drawn from my decade or so on that court. I do view myself as an originalist judge, sometimes lapsing into self-descriptions as a textualist, an interpretivist, a believer in original meaning, and even a judicial conservative. Nuances of differences aside in these terms, I take seriously what I view as my obligation to give reasonable meaning to the language adopted by the drafters of constitutions, statutes, contracts, and deeds. I've taken an oath to the United States Constitution and to the Michigan Constitution, and I take these seriously. I've not taken an oath to abide by the judgments of my predecessors, of course. Yet on more than a few occasions, I've sustained legal precedents with which I was in disagreement. I should add that for the 10 years until the election in 2008, I served on the court with 3 other justices who shared my originalist views, thus giving that perspective a majority on my court. And if there's been any popular criticism of that court during this period, it has been that we were insufficiently scrupulous in respecting precedent. Let me briefly share my own premises and that of my court in reconciling originalist jurisprudence with stare decisis. First, it's been my starting point that the burden of proof rests with the party seeking to overturn precedent. This is so because such precedent reflects existing law, the law of the moment, and because it is incumbent upon a judge to demonstrate institutional humility in the face of interpretations of a law that may have their pedigree in decisions many judicial generations past, in which interpretations have withstood the scrutiny of ensuing judicial generations. It then seems to me hubris and injudiciousness to approach precedents in any other manner. That is, precedents may well help courts to get the law right. They are deserving of at least deference, and to think otherwise, to start each case de novo, seems to me to be little more than judicial solipsism. Second, I have been reinforced in these views by an understanding of the judicial power, the only power that my court wields, in which the idea of precedent is deeply ingrained. Reasonable dispute is, of course, possible concerning the precise contours of the judicial power, defined to me predominantly as the power to say what the law is, not what it ought to be. But I do think that any reasonable understanding of that power encompasses reasonable regard for precedent. And I base this, as does Professor Rappaport, on the historical evidence. I've identified at least 5 instances in which the Federalist papers speak acceptingly of judicial precedent. It seems to me to be part of the common law of the judicial power, just as do certain other forms of judicial restraint, such as political questions, standing, and mootness, all of which in Michigan have been derived from that power in the absence of any case or controversy language. Third, my broader objectives as a judge are not to unsettle the law or to create chaos or upheaval within the legal system. Rather, my objectives are more limited: to contribute to restoring what I view as a responsible jurisprudence toward a traditional conception of the judicial role in which the judge does not do a disembodied form of justice, but does justice under law, in which that judge is cognizant both of the limited authority of courts within our system of separated powers and cognizant of the methods by which he or she appropriately gives meaning to the law. Thus, I am not defensive, although I am often torn concerning my decisions on occasion to defer to precedent. Fourth, the virtues of precedent are well known. Professor Rappaport has summarized them. They are to maintain stability and predictability and continuity within our legal system while ensuring that the rule of law continues more or less to treat equally situated persons in a more or less equal manner. Fifth, I am not oblivious to the fact that with there being parallel legal universes of originalism and stare decisis, an originalist judge is susceptible to the criticism that he can be selectively originalist, committed to its precepts when these serve his interest, and committed to different precepts when those serve his interest. I suppose much the same thing could be said about the manner in which a judge or justice on my court or the United States Supreme Court or any court in which the jurisdiction is entirely discretionary exercises that discretionary jurisdiction. I'm not so much concerned about this criticism, but I do take it seriously, for an on and off originalism is no originalism at all. However, in the end, I think that the judicial power is simply not one in which which is defined by a single value. Perhaps it is my natural conservative antipathy toward utopian notions that things must all conform to a single unifying idea or principle, but I believe it's to caricature originalism to suggest that originalists cannot be true to this jurisprudence if he accords consideration to other legitimate jurisprudential values. And serious exercises in originalism, I believe, involve a multitude of sometimes difficult judgments weighing different aspects of the Constitution's judicial power and also different aspects of the rule of law. At a minimum, I think these both include getting the law right and applying the law even-handedly.